Welcome to the Steadyhand Cafe, where we dive into topics that you've told us are on your mind. They may be directly related to investing or perhaps more general finance in nature. Today, we're digging a little deeper into estate planning with two subject matter experts, Julia Chung, co-founder of Spring Plans, and Lucy Main, co-chair of Wills, Trust and Estate Planning at Weir Folds. Welcome back, Julie and Lucy. And as you know, you are back by popular demand, because our full hour session on estate planning a few months ago proved enormously popular with viewers, and they simply wanted more. In this, one of a three-part follow-up series, we touch on one of the more technical areas that people wanted more information on, which is that of trusts. So whether you're a parent, a grandparent, or somebody related to a family, you might be wondering, how could a trust play a role in your estate planning? And to help us answer that question, let's hear first from Julia and then turn to Lucy.
Well, thank you, David. It is something that comes up a lot for some of my clients who have read about trusts or thought about them, or one of their friends has a trust, and perhaps they've gotten to a certain point in their life where they have, this much money or this many assets, and they're starting to think about the next generation and how things are going to transition. And they say, so should I have a trust? And it's a really good question, but it's sort of putting the cart before the horse, because the trust is a solution. But first we have to identify what's the problem. And so in the first video, we talked about having those conversations about where am I financially, what do I want, and then what does my family want? And making sure we have those communication pieces in place. Once we have that sense of all of those things, then your expert professionals can come in and say, oh, okay, because your assets are owned this way, and we know that you want this, this, and this to happen. Therefore, a particular type of trust is going to come into play. But a trust is a legal structure, which Lucy will be able to talk about a lot more thoroughly than me, but it is a legal structure, and it takes time and money to set up and the same to maintain. So we have to make sure that this actually makes a lot of sense. And also, it's key to remember that a lot of times when we're reading about trust as a concept, it's coming from the United States. They have a lot of different types of trusts, to the point where I'm very confused sometimes about the types and new numbers of trusts that exist in the United States. We have fewer types of trusts that are used in very specific ways in Canada, and I think they have a lot more very specific rules. So to that end, I'd like to hand it over to Lucy to talk about those technical pieces.
Yeah. So as a first step or first point, there are two broad categories of trusts. So there's inter vivos trusts. Those are the trusts that exist while someone's alive, like they're created now and they live now. And then there are testamentary trusts, which are trusts created in your will. And if you're creating a testamentary trust, it's in the will document generally itself. It's not sort of a separate document that's sort of attached to the will generally. And I completely agree with you. I get calls from people that say, I need a trust in place. And my first question is why? I love trusts. Trusts are really interesting because there's some really old academic law that goes along with trust, and the tax piece, which doesn't always jive. And so it's a very interesting area, but trusts are there for particular reasons. And there is a cost to create and to maintain, and the compliance on the tax side that comes with trust is increasing every single year. So it's not something to think of flippantly, especially you need to understand all the tax issues that go along with trusts. But they can serve excellent purposes and meet certain goals. So just a few highlights. So as part of estate planning, we will often see trusts as part of blended families. So couple comes together, one or both of them have children from different relationships. A trust in a will is a great way to deal with that. So you can leave assets to your surviving spouse to make sure they're looked after, but you can control that when they die, the money goes to your children, not their children, if that's the goal. So that's a very common use of a testamentary trust in a will. And that would be called a spousal trust. And as long as you're married or common law and certain provisions of the Income Tax Act are met, then you also get that tax rollover on death that you would have had you given the assets outright. And testamentary trusts are often used for minor children or young children or older children who aren't great with money, addiction issues, not in great relationships, marriages. So trust can be a way to deal with those issues, in some ways protecting the beneficiary from themselves. If a child or beneficiary has a disability, then we might be interested in preserving any government support that they receive, both, at least in Ontario, the money they receive from the government, but also the programs that go with that money and prescription costs that are saved with those programs. So there's special types of trusts that you can put in your will for that purpose. You would not otherwise want those trusts because they come with strings attached. There's issues with them. They're not, there are restrictions. US, so if there's any US connections, we are always concerned about US estate tax, and there are ways to deal with that, special types of trusts for them. And income splitting. So it used to be more favorable to do income splitting trusts within a will pre-2016, but we had a big change in our tax laws then. But there are still ways to split income using a testamentary trust for a family. So you might leave the assets to your child and their children, and then they can split the income, pay for private school fees for camp, extracurricular activities in a more cost tax efficient manner. So those are very common and great ways to use trusts. Inter vivos, probate fee planning is a way trusts are used for probate fee planning. I understand in BC, trusts are often used for wills variation. The legislation that exists there where it's a little bit harder to perhaps not include certain people in your will, but you might be able to do that through a trust. Many people may have heard of estate freezes. So that's where you might own a business, as an example. You want to control the tax that will be payable on your death. So you freeze that value, and the future value goes to a trust for children that you might still want to have some control over. So there are many ways to use trust, but to your point, Julia, don't put the cart before the horse. Make sure there's a real good reason for it, and understand the tax implications of the trust is important.
And Julie, in your experience, is there a kind of a common problem that people present where a trust does make sense?
Well, definitely if you've got minor children and you want to leave something to them, the testamentary trust for minor children makes a ton of sense because, and even for maybe not minor children, my son is nearing age 30, and I'm starting to think that he could possibly handle some inheritance on his own. But prior to that, right. I thought, maybe it would be best if his brain reached full maturity at age 25 before he got his hands on a bunch of money. And right. So there's a trust in my will that says, he can have access to his inheritance at certain ages. And it's actually like stepped for certain ages. And that's a way of getting him used to money. So I'd say that's probably the most common one that I see next to the spousal trust, because blended families are everywhere. And it's super important that we think about kind of what is actually going to happen to those things. Because if we have that spousal trust in place, then your children who maybe aren't related to your spouse might feel like they are actually going to get something out of your final estate, and that reduces estate litigation. And then those living trusts that Lucy referred to, super common in BC where I am, of course, because that Wills Variation Act that we have says that if you leave certain people out of your will, our province steps in and says, no, you must keep them. You must give them some things. And if you really don't want to, then an alter ego trust during your lifetime can help defer that kind of thing. And of course, I definitely see those estate freeze trusts quite a bit. With those living trusts, we have to think about the time frame that we're putting them in place, particularly those estate freezes, because there is this 21-year rule, which I think Lucy could probably speak to a little more.
So testamentary trust, except for some testamentary trusts and most inter vivos trusts, not all, like not the alter ego trust, for example, are subject to a deemed disposition every 21 years. So it's as if the trust sold all of its assets, even though it really didn't, at its 21st birthday, and would have to pay tax at that time. And trusts are taxed at a flat rate of tax at the top marginal rates They don't get the access to graduated rates of tax. So usually, if the trust allows for it, the trust deed, you roll out the assets to the beneficiaries before that 21st anniversary to defer that tax further. But the trust might not allow for that, or it might not be appropriate. Like maybe that person can't handle money. Maybe they're going through a divorce at that time. There could be all sorts of reasons why that's not appropriate. But you're absolutely right. Most trusts will have that deemed disposition. So, a lot of people want to put their cottage into a trust thinking this is a way to keep the trust in the family forever and ever and ever and ever. Well, that's true. But every 21 years, that the growth in that 21-year period is going to be taxed, and that has to be paid. And if the only asset in the trust is the cottage, then how is that going to be paid? So having some thought about those issues. A lot of people use trust to hold their U.S. real estate, their Florida property, Arizona property, so that they're not exposed to U.S. estate tax. You have the same issue every 21 years, so it's like a 21-year plan. Not to say not a reason to do it, but to be more thoughtful about the planning. And on that point, a big issue I see is a lot of people rush to put trusts in place when it's for a tax purpose, like an estate freeze. Oh, I'm buying the U.S. property. It's closing in 2 weeks. Got to put the trust in place. And trusts are very hard to amend if they can even be amended. And it's even if there's a broad amendment provision, there can be tax consequences to amending a trust. And the trust is like a will. If you die, those assets are not necessarily dealt with in your will. And so my big caution to many people is don't rush into doing trusts. You need to do it very thoughtfully. You should assume it's carved in stone and you can't change the beneficiaries, for example. And for some people, that's a reason not to do a trust. But if anything, is to slow down the process and not just think, oh, it saves some tax money, let's throw it together. And then 10 years later, I have to be the bad person to say, like, this is not your asset anymore. You gave it away and now it's held for other people. And that's not a discussion that I like to have.
Well, I guess we should leave it there. We could go so much deeper on this technical topic, but I think both of you have made this actually a really palatable topic. So thank you for cutting through all of the noise on trusts. And we know that there's so much more on this and other topics that are of interest to our clients and Canadians generally. And we're committed to putting out more and more content like this. So I encourage you to subscribe to our YouTube channel to keep up to date on any new videos that we are posting. And if you have any topics that you'd like us to cover, please let us know in the comments on our YouTube channel. And so again, Julia, Lucy, thank you very much for participating in this 3-part series. Appreciate everybody watching. Thanks for tuning in, and bye for now.